Yes, Mr. Birss.
Well, so I was before the short term, just running through the various possibilities that may explain why any one of these statements that one finds in these various messages might have been made that didn't involve some form of mental process caused by the yellow and blue in the sign. There's in fact a perfect example where we know that must be the case. One of the posters whose statement was investigated by Mr. Hing, you've seen reference to that in our skeleton. Mr. Hing was Tesco's in-house lawyer who investigated those Vox Populi messages which he could because they referred to specific products. So you could then go back and look at the date of the post and see whether the product was on offer with respect to the club card pricing campaign at that time. If one looks back at the messages in tab 33 at 809, one finds C58.
What was C? Which category was C, Mr. Birss?
Sorry?
Which category is C? The A, B, C and D are different categories. I'm just trying to get my
Oh,
bearings
these are from Tesco's disclosure.
Right.
And C58 is from a customer in Ireland. Maybe that's why it's in green. I don't know. It's August 22. Hi and good morning. I've just returned from going my shopping in Tesco's in Stillorgan Shopping Centre in Dublin. I understand the grocery retail market is competitive. Like most people, awareness of prices these days. Up until today, I have to continue shopping Tesco's. I'm aware you advertise price-matched items with your competitors, and then he goes on to say purchase these 24 Coke Zero, cross the road to pick up some items, and lo and behold, the same are on sale, and then he complains about it. So here's someone who talks about price matching in a general way. He appears to be comparing the items with Lidl. That's said to be evidence of the price match message being conveyed to him by the sign. But in fact, when Mr. Hing looked into this, and that's at the tab 11 of the supplemental bundles.
Will be in supplemental A, will it?
So it'll be supplemental A, tab 11. I don't know whether you need to take it up, but it's at page 167, paragraph 24. This is one of the ones he's able to follow up on because it actually refers to a product, namely the Coke Zero. But as he points out, Mr. Hing, this was the Republic of Ireland, and he can confirm that Tesco doesn't use any of the signs in issue in the Republic of Ireland. So it's quite obvious from this that, as we might expect, people just make general references to price matching. Where they get those ideas from could be a multitude of sources, but making any kind of assumption as the yellow and blue sign without some evidence of that is, in our submission, not appropriate. And of course, in the present case, we've got the rather likely alternative explanation, which was advanced below, why someone might say Tesco were price matching Lidl, because we know Tesco had been price matching Aldi in a campaign which had been going on since mid-2020, and as we've seen, it's an unfortunate fact of life for Lidl that the public often mix them up with LD and use one name instead of the other, and that's the evidence of Ms Ferrant, bundle 3 at, tab 3 in the supplemental bundle A at paragraph 65, and she confirmed that in cross-examination. Not only do people use the wrong term, she said in cross, they might refer to both companies because they can't be bothered to distinguish between them. So it stands to reason, that being accepted, that where you see a reference to Lidl in a message, there must be a real strong possibility it was intended to refer to Aldi, particularly when the message concerns price matching, and we know Tesco are price matching Aldi explicitly. And once that common ground is accepted, then we submit that unless it's clear from something else in a message that the confusion has resulted from the signage, the court can't possibly assume that the post indicates confusion resulting from the signage, which of course didn't refer to price matching or use the word Lidl. And one can see an example of that. One goes back to the judgment at the end of 113, which the judge obviously regarded as highly significant, and as an answer to the point that the public would see the signs as just advertising club card rather than showing some connection with Lidl. She said, so this is 592 of the bundle, on the contrary, it would appear there's an understanding that the special club card prices are the very prices that are being matched to Lidl. And she then quotes one of the messages, I now like the fact that you price match with Lidl and the special price for club card holders is great. I saved quite a bit today. But of course, if this is one of the people who get confused between Lidl and Aldi, and Tesco are price matching Aldi, the message makes perfect sense. I now like the fact you price match with Aldi, and the special price for club card holders is great. I saved quite a bit today. You've got two different campaigns going on, whereas the judge has assumed, without any basis in the evidence, that the reference to Lidl was indeed intended to be made to Lidl. And in our submission, once it's admitted that it often happens that people make this mistake, then without having some further investigation into these messages, it is simply impossible for the judge to draw the conclusion that she did. And Mr. Hing, of course, he investigated 8 examples, which are the 8 that he could look at because they actually referred to a proper product, and none of them were consistent with it being a Lidl price match confusion, because the goods weren't being discounted on the club card campaign. And the judge was in fact prepared to accept that all these witnesses that Mr. Hing investigated were confused between Lidl and Aldi. So all 8.
Where does she say that?
So he says that at, she says that at paragraph 113.
Oh yes. Yeah.
And well, by implication, paragraph 110, but I think 113 is the conclusion. So, having accepted that, the idea that the rest of them, and of course he couldn't investigate, he didn't have the data, were okay, as it were. They were properly references to Lidl, made no sense. It would have been a remarkable coincidence if Mr. Hing had managed to hit the only 8 by the process that he had adopted. I mean, interestingly, the judge in 113 says, of course, the ones who are confused between Lidl and Aldi are not reasonably observant and circumspect average consumers, even though we know that it is something that happens often. And the second reason beyond that why this evidence was non-probative in our submission is the complete lack of any statistical context for the number of messages relied on. And even if the messages had clearly established the people who sent them were confused by the colour scheme into a belief of price matching, what did that mean so far as the average consumer or substantial numbers of people were concerned?
What do you mean the absence of any statistical context? Is the argument that in order to establish passing off, there's got to be, what, 10% confusion? 20% confusion?
No, but there's got to be substantial confusion amongst
since when has that been a statistical test in passing off?
Well, we would submit that the reason why in both trademark and passing off cases surveys have to have statistical validity is that
that's a different question. The question for the court, let's take passing off because it simplifies the discussion, as you've accepted, is are a substantial number of persons likely to be deceived? And that's always been a qualitative test, has it not?
Yes, but what's going on here is putting before the court some random messages out of an unknown sample size. In themselves, let's assume there were 10. 10, the court assumed that they were the only 10 people. Clearly, that wouldn't look like substantial levels of confusion.
This is a way of testing what the perceptions of real people were.
Yes.
Now, if you reach the conclusion, and it is of course a big if you reach the conclusion that these give you some information about the reactions of certain real people, then why cannot the court rely upon that absent any statistical analysis? What's the role for statistical analysis in this exercise?
Well, let me put it this way. Your Lordship gave the example, or gave the analogy, explained it in terms of a bell curve type distribution where you have tails at either end of people who aren't, let's take trademarks, not average consumers. And I would say not ordinarily perspicacious consumers, the person passing off. And you find a smattering of instances in which, let's say, confusion has happened. Lord Justice Lewison's comments in mind. How do you know that they're not people in the tails or the back tail? The kind of people who just get confused anyway. That is,
but you could say that about any witness who's called in a passing off case. Say they have in fact been confused.
Yes.
You could always say,
yes.
How do I know that this person is representative of the public at large?
It's a particular problem with evidence of this kind, where the judge sees no one. We don't know who these people are. We know what was said. We don't know how or why or what circumstances it was said. I mean, it is incredibly feeble evidence anyway, in terms of its substantive content. And in those circumstances, what's really being done here is an attempt to get home on volume. So they say, oh, well, all right, any one of these might not be terribly convincing, but look, we've got 50 of them. So that some kind of statistical trick is being pulled here by the person relying on the material.
Well, there's two different points here which I'm trying to disentangle. you've made some forceful points about the weight of the evidence taken at face value. But you're now arguing a distinct point, as I understand it, entirely separate from your criticisms of the weight of the evidence.
Yes.
And I'm just trying to understand the legal foundations for this distinct argument.
Yes.
Because no one person is ever representative on a statistical basis.
No.
So how could you ever have regard to evidence from one person?
It's always going to have exceedingly little weight. But if I take the most extreme example, and there are only 2 customers, what is substantial confusion in a tiny sample size? You might say 1 customer is enough, or 2 customers. Let's say both.
Can you name any passing off case where the court has applied a statistical analysis?
Well, certainly there are all those cases where the courts used to look at surveys in a passing off case. Inevitably,
but they're for a good reason, because they are being put forward on a statistical basis. And obviously, if the evidence is tendered on a statistical basis, then you're bound to inquire into whether that proposition is made good.
Yeah, but also it's required. I mean, it's part of the Whitford guidelines. It has to have statistical validity. And the only reason for that is that the courts must regard that as important. That's my submission.
Mr. Purvis, can I put this to you that's been occurred to me as I was listening to the exchange you had with my lord. In paragraph 113,
yes,
which you were drawing to our attention, it's always seemed to me that evidence from, dare I say it without sounding patronising, real people, and that would include this kind of Twitter message stuff. It's come from, there's no suggestion it hasn't come from a real person.
No.
It doesn't mean it's not easy to interpret. It doesn't mean it is easy to interpret, but it has a value because it at least demonstrates what some real people, one real person thought at one time, which isn't always obvious. A court might, in deciding a case, might think no one would ever think this, and if you've got evidence like this,
absolutely,
it has that value. But I think you drew it to our attention already. When the judge refers to Mr. Hing, the point is made that it was a small number. Now, never mind the point you were making that Mr. Hing said, you say Mr. Hing did as many as he could, but that's a statement that's being made by reference to the number, which, at least speaking for myself, only works as a reason if it is statistical.
Yeah.
You can't. It's not relevant to say it's a small number unless you're making some statement of a statistical nature. Is that right?
Well, that's certainly my understanding of what's going on here, and the fact that there are, or the judge perceived there to be a large number in general, was plainly something she thought was significant. If there'd only been one would suppose that maybe the claimant wouldn't have even sought to rely on it.
I mean, it's not said as the statistic, but it's a relative statement. Its relevance by being small is that supposed to be relevant to some larger thing?
Yes.
And I'm not sure what the basis for that would be. Okay.
I'm conscious of the time. I wanted to just, I think I've made the point there. I'm probably not getting any further expanding on the statistical point. I think I've made my submissions that if one does this kind of thing with surveys, it's because the courts recognise that it is relevant. And we've seen in a number of those cases in Interflora that I cited that was the reason why many surveys were rejected. But the other problem is, of course, if you don't call them as witnesses, you're never going to have any idea what they mean. I've dealt with that. Can I turn to what the judge said about the submission? Because she did deal with these submissions, in particular about the Aldi point in paragraph 111. We submit that what she said there was not an answer. First of all, she says, even if I were to adopt Tesco's suggested approach, that all references to price matching Lidl are intended to be references to price matching Aldi, there remain a substantial number of respondents whose comments can't be so readily dismissed I mean, she doesn't say, once again, we're talking about numbers to pick up on the Lord Justice Birss's point. She doesn't say which ones, but one assumes those must be, logically, ones who didn't refer to price matching Lidl, because if all the ones who are referring to price matching Lidl were talking about Aldi, then they would already have been excluded. So those would be the people who were just complaining that Tesco were using yellow and blue, which is not the message, which is the subject of the complaint. The second point, she rejects the suggestion that a proper inference is you can take them as references to Aldi. Well, my more subtle submission, of course, is that even if you can't prove that, which of course we can't as such, nonetheless, the fact that that is at least a perfectly likely situation is enough to dispose of the evidence. But the way the judge deals with it is to say such an inference wouldn't be consistent with the unequivocal H&P evidence of origin confusion of the CCP signs for Lidl. We're going to look at that. That's the Hall and Partners evidence of misattribution in the case of one TV ad that's shown to customers, and in our submission has got nothing to do with the very different case about the price matching message. And then she says, nor would it be consistent with the fact that whilst Miss Farrant candidly accepts that Lidl is sometimes mistaken for Aldi, she doesn't say it occurs most of the time or even a substantial percentage of the time, nor was this put to her. And then she says advertising has done much to minimise instances of confusion. There are 2 points there. One is that the fact that it doesn't happen most of the time or even substantial percentage of the time doesn't mean that it might well not be happening with the relatively small number of people who have posted these messages. But secondly, the judge's account of Miss Farrant's evidence isn't actually correct. If you look at her evidence at tab 3, supplemental A, paragraph 60, page 65. Paragraph 56, page 31.
Sorry, say that again?
Paragraph 56 on page 31. Her evidence actually was that it happened often, not sometimes.
But she's talking about 2015 there, isn't she?
Yes, and then she goes on at 132 C. So now she's in the present day on page 65. So this is, she's talking in the present tense at 132 about the message this sends to customers about price matching. And then in C, she says, like to be made worse because they're actually price matching against Aldi. And people often get Aldi and Lidl mixed up because we're both German discounter supermarkets. So plainly it was often, and it's still often. And she confirmed that in cross-examination. The judge is, in our submission, mistaken in putting this down to sometimes, and it's not being even a substantial percentage at the time. And then when the judge goes on to say Lidl's advertising has done much to minimise evidence of confusion, we would say that is an exaggeration as well, because if one looks at her evidence at page 32, paragraph 61, she simply says, we had begun to see less misattribution, noticing a reduction, less tendency. So minimising sometimes in our submission is not a fair account of what this witness actually said. And it was a very fair point, therefore, that was being made by Tesco at trial about it. Her fourth point is to say it wasn't suggested Mr. Paulson or Mr. Berridge, so they're the witnesses, the members of the public that were called. They had themselves not put in, they weren't responsible for one of the price matching messages. They had complained, they were in the cohort that complained about the blue and yellow and thought it was generally outrageous that Tesco had done it. And therefore they didn't fall into the right category at all. And then fifthly, it said, which seems to be a conclusory point, premised surely on the assumption that's being attacked, it seems to be a reasonable inference that many members of the Vox Populi thought there was a price match to Lidl, thought so because of the use of blue and yellow. Of course, if you can't show that any of them thought there was a price match to Lidl because of the points that we've made, then because they were mistaking them for Aldi in particular, they clearly weren't thinking of that because of the blue and yellow background. And then she says the fact that other comments specifically drew attention to the similarity of the colours provides clear support for that inference. But the people who drew attention to the similarity plainly recognised that this was these were two different companies, and there's nothing to indicate that they thought down the price matching road at all.
That subparagraph 5 is the critical finding of fact, isn't it? I mean, in a sense, the whole case turns on that finding.
Yes.
Because if the thought of price match wasn't caused by the blue and yellow background, then the case fails. So that is the most important finding of fact she makes, I think.
Yes, and we say it simply it follows. It appears to be actually conclusory on the basis of what she said in the preceding paragraphs, rather than, as it were, a separate point disputing what Tesco is saying. But we say, just as a matter of logic, it is not a reasonable inference that they thought that because of the blue and yellow background. Because if in fact they're referring to Lidl instead of Aldi, where we know there was a price match, and therefore you'd expect to see people commenting about it, then that isn't the source of this confusion. The judge couldn't possibly make an assessment about the relative percentage, whether it was many of those or a few or none. It just wasn't open to her on the evidence that was before her, given what the witnesses had said. And the same, and what she did beyond that in 121, 122 is to deal with the, I might call it the significance point. I'm not going to use the word statistical. And saying best understood as representing the tip of the iceberg. But of course, that all flows from her earlier finding, that so far as she is concerned, contrary, we submit, to the evidence, there was a basis for understanding the Vox Populi as representing people who are confused by the blue and yellow. The truth is, none of those people in any of the Vox Populi said they saw it was blue and yellow and they concluded there was a price match. But having made the errors that we submit she's made, then the tip of the iceberg doesn't really follow. Because if the tip is absolutely tiny or non-existent, then there can't be an iceberg. She's understanding that there is a tip represented by however many messages she seems to have thought were significant, maybe 11 or 13 or whatever it was. But we submit there was no basis for that. And that is why we submit it is very dangerous to, as a judge, put your faith in this kind of material. You end up drawing conclusions that simply can't be justified on the basis of the material before the court. Can I turn to the other piece of evidence that the judge placed significant reliance on, because this is the source survey which he deals with from paragraph 124. And she ultimately concludes, after a long examination of this material in 133, that it is qualitatively significant, and then towards the end of that paragraph, consistent with the vox populi, which in itself serves as a cross-check in the exercise of determining whether the participants in the source survey are identified in association can properly be identified as average consumers. So she's, as it were, propping these two pieces of evidence up by reference to the other, and therefore advancing them as being probative of the case. The nature of that evidence, as the judge explains between 124 and 132, it was a survey that took place in June 2020. It was part of the decision-making process to adopt the logo. It's in the supplemental bundle is the evidence that was relied on, which is in supplemental B, tab 25. And the evidence is not the underlying survey itself so much as this PowerPoint presentation that summarises the evidence that was obtained and was then presented to Tesco. I have made submissions on survey evidence. The guidelines that have been given plainly are about surveys carried out in contemplation of litigation.
Can I be clear? Is it your submission that a survey that Tesco itself carried out for its own commercial purposes in order to decide which sign it used and which led it to select the sign and issue is irrelevant?
When one looks at what it's being relied on for, I'm not saying it can never be relevant. What I'm saying is when one looks at this survey, what it could possibly show and what it was relied on for, it did not assist and did not bear the weight that the judge placed on it. That is my
That I understand. But you seem to be submitting, and if you're not making the submission, then we can move on, that a survey of this nature is inherently unreliable.
No, definitely not saying that. Because the survey,
which
any
case
survey
one would
may
wonder
be
why your
reliable.
clients spent good money on it and put their decisions on
Sure,
it.
and in fact, what Tesco say is that this gave us absolute clearance for this because it showed fantastic results.
The true proposition is this is evidence that your client relies on, but you say it doesn't support the judge's finding.
Yes, the judge's finding was irrational as to
that I
what this survey showed. I'm not going to go back over the law on surveys, certainly. Can I just show you what was done? These were members of the public who were properly selected to be by reference to representative quotas. You see it on slide 2. There were 4 lots of 200 people. They were all primary or secondary Tesco shoppers. In other words, they either generally or sometimes shopped in Tesco. And at 353, they were shown first of all shown a fixture on screen for 15 seconds. And the whole point of this was to road test 4 possible label types. So you'll see them on the right-hand side of 353. Option 1 is the top, 2, 3 and 4 as you count down. 4 obviously was the one that ended up being used, but 3 has similarities, but it has that yellow box on the left as well as the blue and yellow. So first of all, they're shown a picture on a screen, which is a made-up shelf, as you see on the left-hand side, which would have one of these options that they were being asked about. So this one, as it happens, that's shown on this page, is the option 1. But the 200 that looked at option 4, it would have had some option 4 signs on it. And they were asked, first of all, as you see in 355, A1, thinking about the image you've just seen, did anything stand out as different to what you'd usually expect to see in Tesco? So they were asked to think about any differences. So if this had been a survey, that might have been an issue with getting it past the court. But obviously, this was for Tesco's commercial purposes, and it no doubt had a useful commercial purpose. Because what then happens is, having been shown that large picture of the shelving unit, not many people notice anything different. So those percentages there are the people who notice something is different. Option 4, it was only 29%. And then they're asked what it was that was different, and you get all sorts of comments, some of which are quoted on the right-hand side of 355. And then according to option 1, option 2, option 3, option 4, they said various different things. They were then asked, they were then shown the actual label itself in the second lot of questions instead of the shelving unit. They were asked the same thing, and the questioning went on that basis. And the judge summarises what was found in the judgment, so I don't need to draw it from there. And she does.
So, do I understand correctly that the page that's particularly relied on is 359?
Yeah, I suspect so. Sorry, I'll just put it away. So here we have, yes, so this is, the judge gives some statistical background to this in the judgment. Yellow box and blue box, option 3. So that wasn't the one that was ultimately used, in that it hasn't been used with the yellow box on the side. 6% mentioned Lidl or Aldi. And option 4 blue box, 4% mentioned Lidl or Aldi. Option 4 obviously is the sign. And the 4% and the 6% I think are of the number that had said they noticed something different. So these are people who are only at the moment looking at the shelving unit, or have looked at it for 15 seconds. They are in fact a tiny number of people compared with the 200 who were originally asked.
Sorry, I may have misunderstood, and forgive me if I've got this completely wrong, but if we go back to 353,
yeah,
Why is option 3 not an example of the signs complained of?
Well, only that the context of it includes the yellow. See where it says £1 in yellow?
Well, to be sure, but,
yeah.
but the club card price
yeah.
is exactly as complained
That
of.
part of it is,
Yeah.
Yeah, absolutely. So, yeah, depending what you look at, you could take both of them, or you could take option 4.
Yeah.
Okay. Depending what purpose you're going to look at them for.
Mr. Birss, just want to make sure I've not misunderstood something you said.
Yeah.
I don't think it really matters, but page 359, I thought you were saying the 4% was a 4% of those who noticed a difference, but isn't it 4% of the 200? Otherwise, the 200 at the bottom on the slide wouldn't make sense.
Well, yeah, I have to say I've struggled with that data, but if you look at the judgment at 128, oh, it is clear, and I'm right.
Yes.
So I'm told that I am right, as it turned, because there's evidence about this, but I didn't want to. Obviously, don't want to spend too much time.
No, fine.
But if you look at the data the judge gives at 1 to 8 by reference to Miss Marks' evidence.
Yes, 1 out of 200.
So yeah, so that makes the percentage make sense if you think of the 29 or 30, but it wouldn't make sense obviously in respect to the 200. Yeah, and then what happened was people were shown the sign itself. Absent the shelving unit, so they could actually see the sign clearly. And at that point, nobody mentioned Aldi or Lidl, and that's yeah. So. And the judge summarises that in paragraph 127 and 128. Miss Marks flagged the little.
Sorry, just on the point you were discussing with my lord, can you help us? There seems to be a discrepancy in the numbers between 127 subparagraph 2 and 128, because 127 subparagraph 2 says 4 people and 2 people, whereas 128 says 3 people and 1 person.
So I think it's because some mentioned Aldi as well, and they were included in the original.
Right, I see.
They were included in the data, and Miss Marks is talking about Lidl. She's actually drawing out
the specifics.
Okay,
thank you.
So insofar as option 3, option 4, it's 1 out of 200. When they saw the shelving on a screen, mentioned Lidl or Aldi at all. And then when they were shown the sign itself, the numbers went down to 0. So those were the results.
What counts as mentioning Lidl? Do we know?
I think any comment.
That looks a bit like Lidl.
Or anything, yeah.
Well, we have some apparent quotes on 359, one of which, for example, is there was a little price mark at the bottom.
Yeah, so that's.
I think 1 or 2 of the quotes, yes, do suggest price matching.
So that's option 1. That's when they're shown the overall shelving unit, and then when we go on, they're actually shown the label itself. We don't get any of those mentions. So there we are. The judge has, in essence, if one averages out options 3 and 4, 4 out of 400, 1% of those who are actually asked to think quite carefully about what they're seeing. Have you noticed anything different? And if so, what? Which might be said not to be the ordinary process that a customer goes through in Tesco, and would certainly give rise to difficulties if one tried to ask it in a court-appointed survey, come up with that answer. The judge says not statistically significant or quantitatively sound. In fact, it was Lidl's evidence at the trial that no significance could be placed statistically on any of this, because Tesco had made that point that it was potentially useful to them, and the judge says, well, it wasn't statistically significant or quantitatively sound. She couldn't draw a conclusion as a percentage of the population, but it's qualitatively significant. And the point she makes in 133 is the respondents in the source survey were primed to think Tesco, but a number of them still answered Lidl. And in our submission, that is a very odd reading of what's going on here. And these were customers who were brought in, asked a series of neutral questions apart from being asked if they shopped in Tesco or had a club card. That was part of the questioning process. But then they were asked, do you notice
by prime to think Tesco?
Yes, but then they were asked, do you notice here anything different from what you would normally expect to see in a Tesco store? Well, in my submission, that's an open-ended question that is inviting the parties to that survey to think about things differently from an ordinary Tesco. And if the suggestion here is, well, they would have been steered away by that question from thinking about anything else other than Tesco, we submit there's no basis for that at all. They were asked on an open-ended basis to think about things that were different. And obviously could send them on a chain of thought to mention other supermarkets if that had come to mind. The suggestion must be here, somehow this process of questioning has stopped them from reaching a conclusion which they would otherwise have reached, which in our submission has got no obvious foundation at all. We submit that is simply simply creating evidence that's not there. I'm sorry. And then she says it's consistent with the evidence from the Lidl Vox Populi. So this is where we get the bolstering of one set of evidence by the other. Of course, if the Lidl Vox Populi are knocked out, which we submit they should be, then the judge's approach to this evidence must be as well, because she hasn't got any foundation in the Lidl Vox Populi for supporting any conclusion based on that evidence. And in the end, we say there is no useful basis upon which the judge, without even hearing from the witnesses, could extrapolate from this extremely limited evidence of tiny number of people the kind of conclusion that she ultimately reached about average consumers and substantial numbers. We submit, therefore, the judge made a serious error in approaching this survey and in drawing the conclusions which she appeared to do off the back of it. Beyond that, the judge relied on the two witnesses who attended court, said to be members of the public, ordinary members of the public, who had been selected from the cohort of people who'd complained about the blue and yellow in the messages, which we have looked at in the box opposite. Our primary submission is selecting two people from these numerous communications which you think are going to be helpful to the case has the usual problem that we've seen in so many of the cases that are summarised in Interflora and the judges have remarked on, that there is no reason to suppose that they can stand proxy for the average consumer or substantial numbers.
The same submission would be made if it was 20 or 200.
The same submission might. It becomes worse and worse the fewer there are.
Because it can't be a question of head counting, can it?
Then we would say, what is he to question of, if I might ask a rhetorical
we come back to the logical endpoint of your submissions, which is that this evidence is irrelevant.
Well, it's not irrelevant in that it tells you the thought process potentially of two individuals. But at what point does that become something which is probative of a case of passing off and trademark infringement? And I suppose a judge who had actually gone through the objective exercise themselves and said, yes, I think the average consumer would be confused or would draw the message that's being suggested, then, as has happened in some of the cases, she might see a particular piece of reasoning explained in the witness box and say, well, I think that's confirms. But at the end of the day, since she has no reason to suppose that these witnesses are typical or can stand proxy, it is not evidence of very much weight at all. And I go back, I'm not going to repeat the discussion I had with Lord Justice Arnold. Unless they can stand proxy, which is the term used constantly in Interflora, what do they represent? I mean, the other problem that's identified in Interflora, where, again, dealing with witnesses selected from surveys, is that if you select them without balance, you only go for the ones you think prove your case, then that itself is illegitimate and misleading, because the judge has only seen, as it were, one set of reasoning. Mr. Berridge, Mr. Paulson, just briefly, Mr. Berridge, judge says that paragraph 15 was an ordinary member of the public. We're not sure what is meant by that, apart from the fact perhaps that he's not in the industry. As his statements at tab 2 of supplemental bundle A, he's a songwriter who has clearly got an interest in copyright protection, as one can see from paragraph 13. He sent his email that was found in the disclosure that was found by Lidl, direct to Erkin, Dykes and Lord, who were Lidl's lawyers, or UDLs. You'll see that at paragraph 13.
I beg your pardon,
sorry.
Give me the reference again.
Sorry, so we're at Sup A, tab 2. The songwriting evidence is at 13. He's saying it's bad to copy things, and he makes a reference to lifting a chorus from Lidl's best-selling #1 single. 14, he decides to contact Lidl. He sends his email to Lidl's lawyers, and it turns out he knows about Lidl's lawyers, as he says in 16, because a couple of months earlier, 3 months earlier, he had been involved in a trademark conflict with Lidl. He'd said he'd tried to trademark a branding phrase that conflicted with Lidl's marks, but it hadn't come to anything. Those events didn't have any bearing on my decision to write to UDL. And then he goes on and says he was happy to give evidence and so on. So he applies to register something very similar to one of Lidl's marks, and he then withdraws it after this dispute arises, and then a couple of months later he sends this message. Whether he can stand proxy for an average consumer, we would suggest not. He's plainly got a particular interest in and knowledge of trademarks, to the extent that he's actually been involved in a dispute with Lidl. And we say, again, the idea that this is helpful when it comes to assessing the average consumer or even a substantial number of consumers is inherently problematic. And the other one is Mr. Paulson. His story is slightly different. He proactively sent a message, this time a tweet, and that's set out in paragraph 1 behind tab 1 of the bundle. There's a screenshot. Suppose it's no coincidence the offer notices appear to resemble a certain other supermarket's logo. And then he goes and finds the Lidl logo and he puts it on his tweet. And it appears that what he was referring to was what's shown over the page, which is the TV advert, which I think we've already looked at a still from it in respect of the Alden Partners survey. And that's what he'd seen, and that's what he says. No coincidence, it appears to resemble #clever admin. And as he says in paragraph 25, he got the impression that Tesco were trying to hint at Lidl, say their prices were also as low as Lidl's. We say, hard to see how those two witnesses really help the actual case. You've got two people, yes, to whom the Lidl logo appears to have been brought to mind. Neither of them were in the shop or in the paradigm case of usage that we talked about, where the real meat of this case turns.
Sorry, I thought you said the Tesco website was one of the paradigm cases.
I'm sorry. There's Mr. Berridge and the Tesco website. You're quite right. Neither of them were in the store. Mr. Berridge was in the course looking at the website. But the key point is both of them were annoyed or cynical about what had happened. They didn't fall into the category of the people the judge is talking about, and neither of them were shown to have been affected in such a way as to change their economic behaviour. That is in the judgment
Well, they had slightly different reactions, didn't they? Mr. Paulson, end of paragraph 16, says that the Tesco promotion had not deterred him from shopping at Lidl.
Yeah.
And 17, Mr. Berridge said it has certainly not encouraged him to shop at Tesco.
Yes, so the opposite. The evidence, yes, that was the reference I was looking for, thank you. So, so far as the behaviour of the average consumer is concerned, we don't get an awful lot helpful to Lidl from this testimony we submit. And yet the judge did place what we submit is unjustified reliance on them at key points in her judgment. For example, on the finding of unfair advantage at 177, and again in 120, where she uses them to bolster the vox populi I'm sorry, it's the other way around. Yes, it's the vox populi bolstering Paulson and Berridge. So again, we've got this bolstering of non-probative evidence by other, we submit completely unprobative evidence, and really nothing here to justify the findings that the judge appeared to think it did justify. But apart from that, the evidence that was relied on didn't seem to be so central to the judge's findings. There was the Hall and Partners survey, which we've already looked at to some extent. It's at supplemental B at tab 27. So this is the one where the various advertisements were considered. One can see them at page 420. And this is in October 2020. So there are some TV ads, 30 seconds and 10 seconds. There's an OOH, which is the out-of-home type of poster type thing. There's a press advert, bottom left. And then we've got social media adverts, obviously similar to the TV ads, the flying ad and the social trolley, and then radio ads. And again, the customers were shown advertisements on a screen. They were asked who the ad was for. So they were dealing essentially with risks of misattribution, particularly. And the part that Lidl liked and the judge came back to was the response in relation to the OOH ad, which is something like a poster you might look at for a short time in the street, top right. Very much like the press ad, which is the one at bottom left. And the overall take from all these adverts was extraordinarily positive in Tesco's favour. We see at 431. The spontaneous brand attribution figures in that pie chart there show only 3% getting it wrong and naming another supermarket. This was regarded by Hall and Partners, as you see at the previous page, 430, as the strongest brand linkage we've ever seen. I think I summarised this evidence when I started, but they'd been working on 14 campaigns, and this was by far the best cut through in terms of brand recognition that they'd ever seen. And as I've explained, this is an industry where misattribution as a result of things like the OOH and other ads is widespread. The judge seized on one part of this evidence, which related solely to the OOH ad, which is that 8% of people shown that poster on the screen for a short time, this is 432, made references to Lidl. So this is classic misattribution problem with this advert, where you can just see the flashes of yellow and blue and maybe not getting enough other information. But we can't, it's difficult to investigate quite what the responses were. We have 3 of them recorded, one of which we set out in our skeleton at paragraph.
Do we not have them at 433?
31. We have 3 of them, yes. So this is your classic misattribution issue, where people take a short look at something and they misread it as an advert from someone else. And the odd thing is these numbers weren't replicated with respect to the press ad, which you can also see the chart at 432, even though that appears to be very, very similar. But perhaps, I don't know why, the numbers are not something which gets called out in respect of the press ad. I don't know whether we've got the actual number, but it's far less than the 8% for the OOH. But even the radio ad, where we haven't got any yellow and blue, as you can see, you get misattribution as indicated by that yellow band. So it's the kind of thing that happens. Lidl recognise it happens all the time with them and Aldi, happened with them and Morrison's, the evidence I gave you. We submit it doesn't advance this case, which is actually about a very different type of link and message that is drawn. The judge refers to this evidence as demonstrating origin confusion. I've already made my submissions about what that means in a case like this, but we submit it's better referred to as misattribution, because it does not represent in any way a shopping experience or an interaction in which any kind of commercial relationship between customer and trader is entered into. And in those cases, there is, as the judge said at paragraph 146, that is to say, the case of customers in a Tesco shop or customers on the Tesco website, there is no prospect of origin confusion. And we submit, therefore, that it's impossible to see what value this evidence could possibly have. The judge points out at 141 the general problem of misattribution caused by adverts which are looked at, obviously, in passing. This is a limited example of that happening in this particular circumstance. The people who were advising Tesco advised them to make more reference to Tesco to solve that particular problem. And when we get to similar surveys which are done later on, the numbers have fallen significantly. Now, we say really this is never going to help the judge on the actual issue in the case, and the irrelevance is ironically pointed out by the judge herself in paragraph 142, where she turns to Tesco's positive points that their adverts were in fact fantastic from a misattribution point of view, and says she is in 142, no doubt that Tesco is right on this score, but then says it's a red herring because Lidl's case isn't concerned with trade origin confusion, and then goes on to talk about the date which it's looked at. But of course, source for the goose, source for the gander. If Tesco can't point to positive lack of misattribution, it can't possibly be probative point to some small degree of misattribution as bolstering the case. So we submit really that could advance the case, not one iota. And finally, the judge referred to so-called internal warnings, which is something one sometimes sees in these cases between 134 and 139. What it is some opinions when one looks at the judgment at 135 from certain individuals at Tesco or advising Tesco who were concerned about the risk of misattribution when used in adverts in low attention media. So it goes to 135. That's where she deals with some references by Miss Webb, who thought Lidl might get some free advertising. And Mr. Marr talks about misattribution risk, especially in low attention media, consistent with and vindicated by the findings of the first entropy report, adds the judge. Again, we submit this is not relevant to the actual message which was complained of in the case for the reasons I've already given. Of course, it's evidence of opinion. The only real basis for relying on this kind of thing at all would be the line of authorities we refer to from paragraph 22 of our skeleton. Who knows better than the trader the mysteries of his own trade, and those references in the authorities. But there are two problems here. The first is, of course, you are cherry picking two people who at one time, although they seem to have been disabused of the idea, thought there might be a risk of misattribution in this context. Against all the people at Tesco who approved the campaign. And once you've accepted, as the judge did, Miss McKettrick's evidence, that the last thing they wanted to do was to create any degree of reference to a rival, one has to conclude that Tesco's general view was not that there was any risk here, and that the adverts were, as they were being told by their advisors, excellent in terms of cut through and identifying Tesco. I mean, the problem here of taking one person's opinion against another it goes back, was dealt with in the case of Australian woolen mills, authorities tab 4, page 657, which we could look at very briefly. That's, yeah, authorities tab 4. This was the case where you can see the claimant's mark was the one at page 43, Crusader surge for some particular type of wool, and the defendant's mark is the one over on 44, which was Caesar twills, and each comprising a man on a horse with the name Crusader or Caesar underneath. The only passage I was going to take you to here is what the Australian High Court said about the evidence. Sorry, I lost it. Yes, here we are. I'm sorry. Yeah, it starts at 56, 657. And what happened here was there was a suggestion that some people at the defendant thought that there might have been some risk of confusion. And here the court say, from about halfway down. In a question how possible or prospective buyers will be impressed by a given picture word or appearance, the instinct and judgment of traders not to be lightly rejected. When a dishonest trader fashions an implement for the purpose of misleading customers, it at least provides a reliable and expert opinion. Question whether what he has done is likely to deceive, moreover can blame no one but himself, even if the conclusion be mistaken, that it will confuse and mislead. But the practical application sometimes attended with difficulty. In the present case, it caused a prolonged and expensive encouraging the states of mind, motivation, intentions of three people whose combined judgment decided the company should adopt the trade brand. And then, so in turn, necessitated an investigation of the steps by which it was obtained, considered and adopted, what was said and done by a number of persons. All this material appears to us no more emerges than though the name and mark were not sought or taken with fraudulent intent, yet 3 or 4 people conversant with the matter saw in them too great a resemblance. Their views were disregarded. By the respondent may have thought they were erroneous, may have thought that if it existed only added to suitability, and then incidentally the issue of intention provided an occasion for the disclosure of much wanted candor on the respondent's side. But in the end it becomes a question of fact for the court to decide whether in fact there's such a reasonable probability of deception, confusion, etc. And this is really the problem of, rather than back to the problem I've made earlier, the point I made earlier, rather than the court decide the matter for itself, we end up sort of subcontracting the decision to the opinion of someone at the time who spoke for themselves but not for the rest of the business. It's unhelpful. So we say the judge's primary error was not to make a decision herself based on an objective account of how the mark would appear to the ordinary consumer exercising those characteristics which the average consumer has and which the ordinary purchaser of Birss passing off has, and then perhaps looking at the evidence to see whether it in any way refuted the conclusion that she would otherwise reach. Instead, she doesn't reach her own conclusion. She reaches for the evidence to try and prove the case one way or the other. And that is a fundamental error of principle. And then the basis of the evidence that she finds, the evidence that she considers and places weight on, was not capable of bearing the weight which she put on it. Indeed, in many cases, she erroneously appreciated the effect and significance of that evidence for the reasons that I've given. And we say that led to a false conclusion about the likelihood of the offending message, if I can put it that way, being taken by the average consumer or substantial numbers of consumers for the purpose of passing off. I haven't referred specifically to the findings on detriment and an unfair advantage, but in my submission that all flowed from the underlying findings in the section of the judgment on the link. Both detriment and unfair advantage, of course, require proof of a change in consumer behaviour, and without the change of economic behaviour implicit in the average consumer believing this was a price matching campaign, there was no basis for any finding of detriment or unfair advantage, and the same goes for damage in passing off. It's right to say the judge on the subject of detriment relied on Lidl's so-called corrective advertising, a passage that you may recall from the judgment, where there was substantial dispute on the evidence about the motives behind that advertising by Lidl. But we say that can't possibly be freestanding detriment. A link causing detriment to distinctive character or repute requires this to have occurred as a result of the consumer changing its economic behaviour, as a result of making the link. If that hasn't been shown, the fact that Lidl may then have put out some advertising because they thought that that might happen is, we submit, neither here nor there. And similarly, on unfair advantage, the only unfair connection between the trademark and the achievement of the objectives of the club card pricing campaign, which was identified, was of course the price matching finding. See the judgment at 177. So it all flows from the same issue. My Lords, we've appealed also on the question of due cause, which I can deal with extremely briefly, I think, because we've set it all out in our skeleton. First of all, although due cause is not a defence to a passing off action, one might anticipate an objection on why are you bothering to run it. We run it, first of all, because, well, in the event that the appeal only succeeded on one rather than the other.
But I don't see how we can arrive at that conclusion when both parties are telling us that passing off and trademark infringement stand or fall together.
Your Lordship's right. The other basis, we say that although due cause is not a defence as such to passing off, when one examines the basis for what we say is the appropriate finding of due cause in the present case, it's essentially the same proposition about mere confusion not being objectionable that one finds in cases like office cleaning companies. So in other words, this is essentially the same arguments that one finds in passing off, that if all that's happened is low levels of potential confusion as a result of the adopting by the claimant of extraordinarily non-distinctive shapes, colours, etc., which are likely to be used by other traders, that kind of confusion is not protectable. We say that's essentially the due cause defence in this case. Where did the judge go wrong? At 183, she rightly cites, we submit, the account of due cause and some of the factors set out by Daniel Alexander KC in sitting as a deputy judge in his decision in Planet Art at 40 to 45. But what we submit is, having done that, she doesn't actually follow through any of those, or at least the bulk of those factors, when looking at the facts of the present case. Thus, if one looks at Planet Art, paragraph 42, the point there being made by Mr. Alexander is that the fundamental issue of due cause. The question whether there are interests of other economic operators having signs capable of denoting their products and services justifying the use of the sign is evaluated by reference to mark and sign as a whole. In the case of a mark composed of a number of elements, the court should consider whether those interests should reasonably permit the use of all of those elements in combination, not merely some of them. Now, of course, in this case, of course, only some of the elements of the mark are being used on any view. The red rim's not being used, the word Lidl, which is the most striking and distinctive feature of the mark, is not being used. That was obviously a highly relevant factor, we submit, but the judge doesn't consider it, and in particular, it would have been relevant to mention in paragraph 186 of her judgment, but she doesn't. Paragraph 43, Mr. Alexander says the approach should not be so strict that it's only where the defendant proves there's no practical alternative at all to the use of the sign in question. Defendant's sign regarded as being used with due cause. There's got to be some degree of latitude, depending on the circumstances of the trade. Points out that it only arises after a finding of otherwise infringement, unfair advantage or detriment, which he says does raise the bar for a defendant to show that the use of the sign nonetheless due cause. But the judge doesn't refer to any degree of latitude here. On the contrary, seems to take the view in 188 and 187 that the primary point was that this wasn't the only choice available to Tesco. So that's essentially giving Tesco no degree of latitude. If they could have used any different sign, this was going to be held to be a case where there could be no due cause. And we say that's an error of law. The point he makes in paragraph 44 is this, that where the mark includes descriptive elements or other elements less likely to have trademark significance, such as colour or design, the easier it will be for a defendant to show that the use of those elements is with due cause. This is briefly referred to in paragraph 186 of the judgment about the colour blue being associated with Tesco and yellow having best impact. But it's not referred to, as it should have been, as reducing the burden on Tesco to show due cause. It's just left hanging, and in the end the judge applies what we say is a bit of an extreme position, which is that if Tesco could have done something different, then there couldn't be due cause. That's essentially the conclusion in 188, we submit.
And in what circumstances is one realistically going to come to the view that not merely that advantage has been taken, but unfair advantage has been taken, and yet it was with due cause?
Well, that is.
I mean, that's not what. It's not precisely what the Act says.
No.
The Act says use of the sign being without due cause takes unfair advantage of.
Yes.
I find it odd that you could come to a conclusion where you said, yes, this sign takes advantage of the mark. That advantage is unfair, but it's with due cause. It doesn't sound very logical to me.
No. One of those wonderful legacies we've been left by the European Union. It's not, we would submit, particularly logical. It does require the court, however, to go through a process of balance, and whether in fact you say due cause should be regarded as part of the unfairness test.
Well, that would make more sense from
just
looking at it by the light of nature, that you would say, well, it's due cause, therefore the advantage it takes is not an unfair one.
The judge could have done that. But she doesn't do that. She doesn't raise these issues when she looks at unfairness. So I'm kind of obliged to look at them in this particular silo. So yes, I entirely understand your Lordship's point. I don't think I have a sensible answer to that. But I think that's a fault of the statute that we're having to apply. But in the end, some kind of balancing exercise has to be gone into. And we say this is an extreme case so far as Tesco were concerned. They had gone to an enormous amount of trouble to have this designed by third parties, to have it checked and tested, road tested with the public. They've been told by their advisors that this was the best one to go for. They were told it had fantastic cut through with consumers, and they would not have done it, as we've heard, if they thought there was any risk of association with a third party. And in the circumstance where all they've taken is their own blue and a yellow roundel, which is common in the industry to indicate value, we say this is a classic case where the court can say there is due cause. You checked the market, you found there was no likelihood of any real damage. Actually, what was shown in any event was pretty minimal, even on the judge's own approach to the evidence. And the judge doesn't even weigh that. She doesn't say, well, I've looked looked at the sheer amount of disruption and damage that this is causing and have weighed it against what is a perfectly legitimate expectation of Tesco, she just says, well, you didn't have to do it.
What do you say about what the judge says in 188, where she draws attention to Mr. Follett's query about why give up the yellow price tile? The response from Mr. Gilbert, not called, non-negotiable, no explanation.
Well, the this is going to the point that where she concludes that Tesco could have used a different sign. And they weren't forced to use this one. We don't dispute that. Tesco could have done. They wanted to use the yellow because, and I've shown you the evidence on this, it was the best way of showing value. This individual has raised a query, but it's all of a piece with picking pieces of testimony like that out. It's not the right approach. The right approach has got to be to look at the whole picture, not what one person may have suggested. We say the judge just didn't do any kind of balancing exercise here of the interests of the free market against the at best limited disruption which she had found, we submit wrongly, she had found would occur to the trademark. This therefore was an unusual classic case for establishing duty. As I say, we say it's essentially the same argument in passing off, that all that's creating whatever confusion the judge may have held is the taking of commonplace elements, and indeed one element which is already distinctive of Tesco itself, and simply not something that can be legitimately complained of. Lords, I'm very conscious of the time, and Mr. Cuddigan has to follow on the question of copyright, but unless I can assist you any further on the issues of trademark infringement and passing off.
Thank you very much, Mr. Davis.
My Lords, there are two copyright appeals. The first appeals against the trial judge's finding of infringement, and that involves complaints about the approach taken to subsistence and infringement, but not copying. The second, which will be quite quick, is against a decision to grant an injunction prohibiting infringement. And there is a common thread running through all our submissions on copyright, and it resides in the amount of originality in the work in issue.
If the trademark appeal fails, then the injunction appeal
has no utility.
Has no utility.
Absolutely. We conceded before the judge, and we maintain the position today, that if we lose on trademark infringement and passing off, injunctions are appropriate, and therefore Tesco will have to stop using contested signs.
Well, I think I can say that we will only consider, we'd like to hear argument on both copyright appeals, but we will only give a judgment on the injunction appeal in the event that the trademark appeal succeeds.
Of course. So our complaints about copyright at heart are a submission that there was no real creativity involved here, because the work in issue was substantially copied from an earlier Lidl logo. And in that regard, the judge misapplied the law on antecedent works. If we're wrong about subsistence, and there is a copyright work here, it is wafer thin, and Tesco's design agency could, in those circumstances, have taken no more than the idea of that work, and so no substantial part. And then a corresponding analysis applies to any damage caused if there were infringement. It's common ground that for present purposes, damage should be assessed by reference to a notional royalty. And if our submissions on subsistence had merit, it should follow that the objective value of the copyright work was very low indeed. we say that position is effectively established by the availability on the market of licenses of very similar works at low or even no charge. So in light of the massive cost to Tesco of rebranding, there should be no injunction. If I could start with the facts regarding the creation of the work in issue, the mark with text. Could my lords take supplemental bundle A and turn behind tab 4. This is Mr. Unterhalter's second written statement. This was the only evidence at trial on this issue. It was unchallenged. If you have it loose, it might help to have our skeleton to hand at the same time, which is in the core bundle tab 25, and I will be taking you to page 514. Core bundle, I think that's core B. Yes. So if you could turn forward, please, in supplemental A to page 75 and paragraph 18 of Mr. Unterhalter. He is describing there the stage 1 logo that you see under paragraph 71 of our skeleton on the left hand side, stage 1. He says the stylized little text itself dates back to 1972-73. I'm in paragraph 18. Now that may have been a copyright work. It doesn't matter for present purposes because there was no reproduction of any part of that logo. Stage 2 is described in the very next sentence. Around the beginning of the 1980s, a circular logo was created in the form of a yellow circle with red border, with the Lidl stylized text superimposed upon it. And that is the right-hand image under paragraph 71 of our skeleton. It may or may not have had the words ist billig there, which means is cheap. Again, it doesn't matter, but it definitely had the yellow circle with the red ring around it, although that red ring is not particularly clear from the photograph.
Now, pausing there, would you dispute that copyright subsisted in both of those works and copyright therein was owned by Lidl?
I don't accept it, but it's not highly material. It's not material to the infringement claim. So
how could it be disputed?
Well, the first one has a reasonable claim to copyright, but it doesn't matter. The second one, if one takes out the ist billig, let's assume it doesn't have that there, and it's just a yellow circle with a red ring. I don't accept that would be an independent copyright work. Now, my lords, we know that the designs of stage 1 and stage 2 took place 9 or 10 years apart, and there's no reason to believe that the work was done by the same person or people. So there are.
Why does it matter whether it's the same person or whether it's several if they're all employed by the same company?
Because it's not, they're distinct copyright works.
Okay, so you referred earlier to the expression antecedent works, which rather triggered a recollection in my memory, because there's a whole line of case law on this subject, none of which is cited in any of the skeleton arguments and doesn't appear to be referred to the judge. So we think of cases like LA Gear and High Tech, we think of cases like Sweeney and Macmillan, and there's a whole series of cases. So let's take the Ulysses example. Each chapter, it was held, would be a copyright work in its own right. And when you add in a new chapter, it doesn't destroy the copyright that pre-existed and the previous chapter.
Absolutely right. Absolutely right. But if author A writes the first chapter and author B, 10 years later, writes the second chapter, author B does not get any rights over the first chapter.
To be sure. But if A and B are both employed by the same company, the company owns all the rights.
Right. Indeed they do, but they weren't sued on. Moreover, if there is just one integer of similarity with work A and one integer of similarity with work B, you cannot rely on both those integers of similarity in a single cause of action. What you have instead, and what Lidl had here, was two potential causes of action. So consider the position where someone made an unlicensed copy of that stage 2 work, and let it be that there is copyright in both of them independently. Okay? That copy.
Sorry to interrupt you, but I mean, where these debates tend to pinch is when you've got term of protection issues, or if the copyrights are in different ownerships.
Yes.
Of course, if the copyrights are in different ownerships, or one has expired and you're trying to sue on the later one, then these questions become important. But we're not concerned with that context.
No, the reason they pinch here is because the rudimentary nature of the marginal contribution. And if you bear with me a moment, I hope my position will become clear. Consider the position where someone made an unlicensed copy of what you see on stage 2 on the right-hand side under paragraph 71. And again, let's ignore the ist billig and assume it's just the word Lidl in there. Okay? Actually, that doesn't really matter. That copying could be the subject of two distinct copyright claims. One by the author of the stage 1 work, who would be able to rely on the reproduction of their text logo design, and another by the author of the stage 2 work, who could rely on their yellow circle and red ring. Neither case would be particularly strong. Indeed, the second case would be weak, because the contribution of the stage 2 author is both modest and commonplace. The newer additions are the yellow circle and the red ring. The stage 2 author cannot rely on the design of the little text, because they didn't originate it. So as a matter of law, these would be two distinct causes of action, and there is no legal mechanism by which the work of those two authors can be combined or accumulated into a single work. The position as a matter of principle is no different from one in which the stage 2 author started by copying a complete stranger's work. The most that Lidl could do would be to obtain title to the two distinct causes of action. And the result would be that they owned a pair of weak claims and not a single stronger one where they could rely on all the reproduced elements. Now, this becomes important when we move to stage 3, which is paragraph 19 of Mr. Unterhalter's statement. He says that later, around the late 1980s, a square version of the Lidl logo was created in the form of a blue square with those circular elements and the stylized Lidl text superimposed on it, forming the mark with text. Mr. Sander thought that the blue square might have been first added to the yellow circle with red ring at some point in the 1980s to create a convenient flag shape which could be easily fabricated as signage, but he did not know for sure. So, my lords, a square version of the already existing Lidl logo. A blue square was added to the yellow circle with the red ring, possibly to make a convenient flag shape. Now, there was some debate at trial about copyright in collages, and my learned friends refer to collages in their skeleton argument, and it's instructive to consider this evidence in the context of collages.
Just before we get on to the law about collages, can I just understand, Mr. Unterhalter goes on to deal with the question of authorship and employment in paragraph 21.
Yes.
And you told us earlier that there was no challenge to his evidence, so I take it, therefore, there's no challenge to the evidence that it's probable that all the works in question were created by employees of Lidl Stiftung who would have been German nationals at the time.
That is correct. There's no challenge to that.
Thank you.
So, collages, we say an artist can get copyright protection from a collage, but a collage involves choice and composition. It involves choosing images from innumerable drawings, paintings and photos that are available to an artist or author, and then choosing their sizes, orientations, colours, positioning, etc., with the result being something that is entirely new. And the sheer number of creative choices involved in that selection of images is liable to be huge because the source material is almost unlimited. But that cannot be read onto what is happening here. Mr. Unterhalter's evidence is that the Stage 2 logo was the starting point for the Stage 3 logo, and that a blue square was added to it. And now we need to consider how the law of copyright responds to those facts, and in particular, does it award the author of this blue box with a posthumous 70 years protection? It's common ground that the approach to copyright developed under EU law is to be applied. I'd like to turn up just a couple of the authorities, starting with Painter and Standard Verlag, which is at tab 28 of the authorities bundle, which is authorities 2. My rules probably know this is a decision of the Court of Justice in relation to copyright in photographs. The claimant was a portrait photographer. The photographs in issue were not only composed and taken by her, they were also developed by her, and when they were subsequently published without the necessary attribution, the defendant newspapers challenged subsistence of copyright. They asserted that the creative freedom allowed to the author of a portrait photograph was so small that no copyright would result. If I could pick it up, please, in paragraph 87, bundle page 878. The court refers there to InfoPack and the originality test, the author's own intellectual creation. And then over the page, the reference to recital 17 to the Information Society Directive, the corresponding requirement that the work reflects the author's personality. At paragraph 89, what is required for that is that the author was able to express their creative abilities in the production of the work by making free and creative choices. And then at 91 and 92, the court states that a portrait photographer could do this in several ways and at various points in the production. They can choose the background, the subject's pose and the lighting, the framing, the angle of view, and the atmosphere created. They can choose from a variety of developing techniques or to use computer software. And through these various choices, they can stamp the work created with their personal touch. Note, please, the terms of paragraph 93. Notwithstanding this array of creative options, this is not a clear-cut decision. The court says, consequently, as regards a portrait photograph, the freedom available to the author to exercise his creative abilities will not necessarily be minor or even non-existent. Not necessarily. One can infer that the court considers that one could have a portrait photo where these choices, the choices that they've called out, were so trite as to fail the subsistence test. And we get a further flavour for what is required for this intellectual creativity from the InfoPack case. We don't need to turn it up. But as you know, that concerned copyright in excerpts of 11 words taken from Danish newspaper articles. Even if the pool of available words was only 10,000, there would still be 10 to the power of 44 possible choices for a combination of 11 words. There are plenty of options there in 11 words. I'm going to contrast that with the sort of choices, the sort of decisions involved in the present case. Moving on to infringement, we know that the same test, the test of intellectual creativity, is now applied to infringement. And InfoPack tells us that an infringing copy must contain an element of the work which, as such, expresses the author's own intellectual creation. Now, if one considers how that works as a matter of logic, if one has a massively creative work, it could be infringed by the taking of a small part of it, because even that small part would still reflect the free and creative choices of the author. Conversely, if the work just squeaked past the subsistence test, infringement would only be established where it was copied and reproduced almost identically, because anything less than what was taken would not comprise the intellectual creation of the author. And that is in effect the explanation of InfoPack, paragraphs 45 to 48, provided by my Lord Justice Arnold in THJ and Sheridan at paragraph 27. Ideas and expression. The ideas-expression dichotomy also informs consideration of subsistence and infringement. The exclusion of copyright protection for ideas is rooted in the Berne Convention, and from there it passes into our law through Article 9(2) of TRIPS, which says copyright protection shall extend to expression and not to ideas, procedures, methods of operation, or mathematical concepts as such. No protection for ideas means that if only an idea has been copied, the result cannot be infringement. And to that end, we referred you in our skeleton to a quote from Coppinger. This is under paragraph 76. Copyright law is not concerned with the reproduction of ideas per se. If the idea embodied in the plaintiff's work is sufficiently general, the mere taking of that idea will not infringe it. And we say that is in substance what Lord Hoffman was saying in Designers Guild in the highlighted passage, which is Authorities Bundle 1, Tab 7, page 120. I'm coming on now to antecedent works, and it's our submission, it was our submission to the judge that any alleged copying had to relate to the contribution of the Stage 3 author. And we suggest that support for that submission is found in the 19th century case of Dix and Brooks, which is in the Authorities Bundle, tab 8.
But if Lidl owned copyright in Stage 2
Yes.
and copyright in Stage 3, why can't they say, well, you've taken bits of both?
You can. Well, there are two answers to that. Firstly, that wasn't the claim. They sued only in the copyright in the last logo. They didn't assert the Stage 2 logo. They could have done that. Let's consider how it plays out if they do. The infringement claim in relation to the Stage 2 logo, they say, well, you've taken our yellow circle. You haven't taken the red ring. You haven't taken the little text. You've taken our yellow circle. So let it be that there's subsistence for present purposes. When it comes to considering what's been taken, it is a yellow circle and nothing more. And so my submission will be a yellow circle that is as rudimentary a shape as one can have. That is not a copyright work. That is not a substantial amount of creative decision making. A yellow circle is insufficient. Then you say, well, what about the Stage 3 logo? So fine, let's consider the Stage 3 logo. The only contribution of the Stage 3 author was to add a blue square. So again, they have the same problem. Let it be that copyright subsists for the present purposes. Let's think about infringement. What's been taken from the Stage 3 author? Only the blue square.
So is this a question of pleading, or does it go beyond that?
No. It's a question of substantive law, because what they're left with, at best, is two distinct claims. They own copyright, let's say, in the Stage 2 logo, and they can say, from that, you took a yellow circle. Let's say that's below the threshold of intellectual creativity. That claim fails. Then we look at the claim that the Stage 3 author can advance. He says, from me, you've taken a blue square, because that's what I contributed. And that is below the threshold as well, because it's just a blue square.
So the consequence of this argument is you can never have copyright in a work of co-authorship.
No, you can, but these weren't works of co-authorship. The evidence wasn't that two people sat in a room collaborating to do this. The evidence was 10 years before, you've got stage 2. That's done. That work is complete. 10 years later, someone takes that work and adds to it. That is not a work of collaboration. There's no reason to believe it's the same person. It's not the same. It's like adding a postscript to someone else's novel. You haven't collaborated, or a preface to someone else's novel. You don't get rights in the novel to which you write a foreword. These are distinct contributions, and there's no evidence that they were made. We know they weren't made at the same time. There's no evidence they were made by the same person. So that is why I say it is as if the Stage 2 logo was designed by a stranger and Lidl take an assignment of the right to sue for copyright infringement in it. They've got that. They've got a right to sue for copyright infringement in relation to Stage 3, but they can't combine the creative decisions of those two authors. There is no legal route by which that can be accomplished, absence collaboration, and there's no evidence of collaboration, and the timing points against it. It's not pleaded as a collaboration. So, my lords, authorities tab 8, please. Authorities 1. Dix and Brooks.
Just before we get into the detail,
Yes.
can you just help me on the more general question? You've been emphasising, and with justification, the test we have to apply is the European test, which has its origin in Infopac in 2009,
Yes.
rather than the traditional common law English test.
Yes.
So how are we helped on applying the European test from 2009 by an English authority from the 19th century?
So this is an authority about the principle of, I say this is an authority of general application about whose work gets protected and whose suit. And there's nothing inconsistent with it and Infopac, because Infopac isn't telling you that you get credit for someone else's creative decisions. This isn't about the, perhaps my lord, this isn't about the threshold for protection. This is about a different point. So that the facts here were that the defendant had made an engraving of The Huguenot by Sir John Everett Millais, and the claimant had distributed a knitting pattern for The Huguenot, and he had copied the defendant's engraving in order to do so. The defendant published a circular deriding the knitting pattern as an infringing copy, and the claimant sued for damages and an injunction. The defendant counterclaimed for copyright infringement and succeeded at first instance before Vice-Chancellor Bacon. If I could pick it up, please, in the claimant's submissions on appeal, on page 143. His position in law was that there were two relevant statutes, the first of which gave protection to what was called the designer, and the second of which extended protection to an engraver. The submission at the top of 143 is this: we contend that the object of the Act was not to protect designs, but to prevent rival engravers from copying each other's work, and that there is no piracy unless something is copied which constitutes the work of the engraver as distinguished from that of the painter. The Acts 8 George 2 chapter 13 applied only to prints where the engraver was also the designer. The Acts 7 George 3 chapter 38 extended the protection of the former Act to prints of which the engraver was not the original designer. In both the Acts, what is forbidden is the copying of the prints, not the reproduction of the designs. The work of the engraver is what is sought.
This takes us into the vexed question of what Graves' case did and not decide,
Right.
which involves archaeological investigation of the relevant statutory provisions of that time. And there's a great deal of academic ink being spilled on that subject.
I don't think it is going to involve that, but I'll stand to be corrected. We say that this is not a copy of the engraving. Admitting the design to have been taken from the engraving, there's no copying of anything constituting the engraver's work.
Yeah, because this is a signal copyright, not a content copyright.
If I could take you forward, please, to the judgment of Lord Justice James on page 145. Third line. It appears to me that the Vice-Chancellor fell into, if I may venture to call it, the error of supposing that the case was within Acts George 2, chapter 13, which gave protection not to a mere engraver, but to a man of genius who by his industry, pains and expense invented a design. And picking it up at the next paragraph, those words were intended to give protection for the genius exhibited in the invention of the design, and the protection was commensurate with the invention and design. That act was afterwards extended to embrace the case of persons engraving from something which was not the design of the engraver. Now it appears to me that the protection given by the subsequent acts to the mere engraver was intended to be and was commensurate with that which the engraver did. That the engraver did not acquire against anybody in the world any right to that which was the work of the original painter, did not acquire any right to the design, did not acquire any right to the grouping or composition, because that was not his work, but the work of the original painter. And we say that is an obviously correct proposition of law. Copyright protects skill and labour of the creator, the author, who contributed that skill and labour. And you'll see that reflected in an excerpt from the Modern Law of Copyright, which is in Authorities 2, tab 39.
$35, did you say?
Tab 39, my lord.
39.
Picking it up at, so there's a paragraph at 439 discussing originality, ideas, and taking a substantial part. And at 440, essentially the point is that the author is not entitled to be protected against copying, save of that which is his work. And then there's a discussion of similarity between one artifact and another, as to which the authors say at the end, part of what is present in the first artifact may not be the work of the first artist at all, but may have been derived by him from an antecedent source. And of course, that is, we say, what happens here in relation to the stage 3 logo. And there's an illustration over the page, which we say is apt. An architect complains that a builder has copied his plan for a house. It turns out that only the garage was copied, but the garage was not original to the architect. He had taken it from a prior design. No doubt the house has been designed so as to be sympathetic to the garage, but the architect does not get right to the garage design because that was not his work. He did not take those creative decisions. The author of the Stage 3 logo did not decide to incorporate a yellow circle. He slavishly copied the yellow circle. It was not original to them. They don't get any rights in it. My lords, moving on to the judgment on subsistence, we have 3 complaints. First, it ignores the distinction between the contributions of the authors of the Stage 2 and 3 logos. The judge's approach is, in effect, to give credit for Millet's creative decisions to the engraver. Second, it relies on old authorities as to the test for subsistence, so sweat of the brow, skill and labour, and not intellectual creation. And third, it relied on evidence which was legally irrelevant to the issue at hand and in what did not support the proposition for which it was relied. Could we start, please, in the judgment at paragraph 286? Core Bundle B, tab 28, page 646. About 6 lines down, the judge accurately records our submission. She says, Tesco contends that the stage 3 designs were developed over some 20 years in 3 distinct stages. Those facts were and remain common ground. Involved negligible additional artistic skill and labour, and in any event incorporate elements in the form of the blue square and yellow circle created by different authors, such that there is no principal basis to consider the skill and labour involved in the design of those elements per se, together in one copyright work. That is an accurate record of our position both then and today. And that per se is important. The design of those elements per se is to be contrasted to any decision to recycle elements that were already in circulation. Then, but back in the judgment, thus Tesco says that none of the skill and labour involved in producing the stylised Lidl text logo can be protected by the design of the circle logo, and that similarly none of the skill and labour involved in producing the stylised text logo or the circle logo can be protected by the addition of the blue square in the mark with text logo. The language is not quite right here, but we think the judge's intended meaning was correct. It would be more accurate to say Tesco says that none of the intellectual creativity involved in producing the stylised text logo can be protected at the suit of the author of the circle logo, and conversely, circle logo and blue square logo. Moving on to paragraph 287, we see the judge rejects that case. And the first reason she gives for rejecting it is that the stage 3 logo is a combination. She says that we conceded in opening that if an act of combination is artistically significant, then copyright will protect that artistic combination. That is the collage point. We do accept that if an author makes a host of creative decisions, creative choices in assembling a collage, the resulting assembly may attract copyright protection. But that does not gainsay our argument at all, because the collagist does not get rights in the earlier works that they have deployed for their collage. Their rights are limited to the combination. So the fact that collages or combinations can be protected is not a reason why the creative choices of the stage 2 author accrue to the benefit of the stage 3 author for the purposes of subsistence. They do not. The collage copyright must be judged by reference to the choices involved in combining and not those involved in creating the elements that are being combined. We will come back in a moment to consider the factual question of the choices that were involved in combining here. Now, in support of her decision, the judge relied on Ladbroke and William Hill, but this point was simply not before the House of Lords. In Ladbroke and Hill, there was a single literary work in issue, the betting coupon. It was said to be a compilation, and there was no suggestion that it had not been all devised at the same time in a common endeavour by its authors. The defendants attacked subsistence by arguing that the individual parts of that coupon were too trite to attract copyright protection. And they said that if that was so, then the whole compilation would also be denied copyright protection. But that was an obviously bad divide and conquer argument, and Lord Reed dismissed it as such in the paragraph that the judge has quoted here. But what he did not say was it did not matter whether subsidiary elements of a work, he said it did not matter whether subsidiary elements of a work crossed the threshold for subsistence. What mattered was whether the whole work did. And he pointed out that the devising of the arrangement of constituent elements might itself be the result of significant skill and labour. Well, that's all true. What it doesn't say is that if Ladbroke had taken their design, copied someone else, that they got rights in what they had copied. And that's the issue that was before the judge. Does the stage 3 author get rights in what they copied? Obviously not. There is one qualification to make in relation to Ladbroke and Hill, which is that in light of InfoPack, the question of whether an element of a work would qualify for subsistence may matter for infringement. Because if all that has been copied is that element, and the element itself is insufficient, then the infringement claim must fail. Moving on in paragraph 288 of the judgment, the judge says, the act of bringing together the little text with the yellow circle and the blue background was an act which involved skill and labour. We're not entirely clear what's meant here. The only act carried out by the stage 3 author was to add a blue square. There was no bringing together beyond that. Blue square aside, all that author did was to slavishly copy someone else's stage 2 logo. The only choices made by the stage 3 author related to the selection of a square frame, the shade of blue used, and the size and position of that frame. The literary equivalent of those choices would be 1 or 2 words. Continuing in the first sentence of paragraph 288, the judge refers to the combination of colours and shapes and the orientation of the various elements. The judge is giving credit here for creative choices which were not original to the stage 3 author, which were slavishly copied by that author. The stage 3 author added a single colour and a single shape. And they did not orientate various elements. Then at the end of paragraph 290, the judge refers to Lord Hoffman's statement in Designers Guild to the effect that originality tends to lie in the detail in which the basic idea is presented. And she then states, whilst Lord Hoffman's observation was no doubt apposite in the factual context with which he was concerned, I do not consider it rules out the potential for copyright subsist in a combination of shapes and text. Ultimately, the litmus test must be whether the mark with text involves the exercise of intellectual creation involving the expression of free choice. In my judgment, it does. Again, my lords, the plural of shapes here is wrong as a matter of principle. And we do not understand how the judge can rely on text at all. The text had been there since the 1970s, with precisely the same font, design, and colouring. These were simply not decisions taken by the stage 3 author, which can weigh in their balance when it comes to assessing subsistence. Similarly, paragraph 299 on infringement
Two nine nine.
299. I've got a bad reference there. I'll will chase that up. I've got the quote I have here is, in my judgment, the blue background with the yellow circle plainly forms a substantial part of the mark.
That is
Oh yes, there we go. Plainly forms a substantial part of the mark with text.
Yeah.
With that sentence in mind, could you turn back to our skeleton on the appeal, which is core bundle.
How long is this point going to take, Mr. Coddigan?
2 minutes?
Oh, fine.
Core bundle B, tab 25,
yeah.
page 517.
Yes.
Just above page 83, you should see that I have slavishly copied Caravaggio. And I've added a square blue background to his work. According to the judge's approach, that was an act of combination, and the act of bringing together Medusa and the blue background involves significant skill and labour. As a result, copyright will subsist for some 70 years after my demise, but more importantly, that copyright covers the whole combination, and that as a result, I would be able to rely on creative decisions which were taken by Caravaggio in 1596 in an infringement claim in 2024. That approach is clearly wrong in principle.
Well, on that rousing note, shall we call it a day?
Very good.
10:30 tomorrow.
All rise.
Still on.
Very well judged.
You're right there. I'm good.